Good afternoon. It truly is my pleasure to introduce you to a woman who is passionate about helping others to function with more ease in workplace settings. Marian Vessels is the director of the Mid-Atlantic ADA Center since 1996. She provides training and guidance on the Americans with Disabilities Act as it relates to employment, state and local governments, arts, and hospitality. Previously, she was the executive director of the Maryland Governor's Committee on Employment for People with Disabilities and the director of the Maryland Governor's Office for Individuals with Disabilities. We are grateful to have Ms. Vessels here with us today. Please join me in welcoming her.
Thank you. Good afternoon. I am going to do the presentation, and I would ask that you would hold your questions because we've got a very short period of time, and I want to make sure I get through the information and then be able to answer your questions. And I will stick around afterwards if you have questions, so if I don't get to yours, then I will be able to address it at that point. The PowerPoints are on your thumb drive in your bag, and they will be posted on DI's website so that you will have access to them. But I hope this information will give you a basis for moving forward and learning and understanding the reasonable accommodation process under the Americans with Disabilities Act. This first slide shows the signing of the ADA that happened in a week and a half. It'll be 26 years ago. And I was fortunate enough to be on that White House lawn. And so this is something that I've been very passionate about and have lived the last 26 years under the ADA. This is my contact information. And I've got materials up here as well as a sign-in sheet. And in fact, if you could pass that around, the sign-in sheet, if people would like information, it's right up here with a pen. If you'd like to get information from us, we'd be happy to share it with you. I've got 3 quick questions for you. The chance of having a disability for those who reach the age of 65 is A12, B23, C36, D82. What do you think? Shout it out. C? You bet. C. And that's from brand new statistics that just came out. So at least 1/3 of the population, I've seen estimates as high as 1/2 of the population will have a disability after the age of 65. That's a huge amount. Wow is right, isn't it? Next question. Over 50% of the accommodations for employees will cost nothing, between 50 and 100, or 500 and 1,000, over 1,000 or more than an employer can afford. What do you think? Oh, I just realized I put the wrong letter, but it's nothing. Sorry about that. But the word is right, nothing. So many of those are schedule adjustments, flex schedules, supports that can be built in, modifying where your desk is, bringing headset from home, supervisory changes, doing more things orally or more things written, any number of accommodations. The next question, true or false? The ADA is an affirmative action law for individuals with disabilities. What do you think? I got a lot of quiz. It's false. It is not affirmative action. So you don't have to hire a person with a disability just because they have a disability. Okay? The ADA is all about civil rights. It's a civil rights piece of legislation. So what is the ADA? As I said, it was passed in 1990. It is civil rights that says it's illegal to discriminate on the basis of people with disabilities in employment, state and local government, private businesses, telecommunication, and transportation. The goal of the ADA is full inclusion of people with disabilities in American society. And again, employment, state and local government, public accommodations, telecommunication, and then kind of a general miscellaneous. Who is covered? Who must comply with the law? It's any entity that has 15 or more employees. Okay? anyone that has 15 or more employees, any public government entity, state, local, city, county, borough, any of those entities, no matter how large or small, are all covered under the ADA. And then there's a big category of privately operated businesses that have 15 or more employees that are going to be covered under the ADA. Now, who is a person with a disability under the ADA? It's someone who has a physical or mental impairment that substantially limits a major life activity. So anyone with POTS, anybody with any number of very broad definitions of disability is going to be covered. An individual has a record of somebody maybe with cancer that has now been cured, or they used to have a disability, no longer do, but they have that medical record. Or somebody who's presumed to be disabled, maybe somebody with a disfigurement, and people say, oh, they look like they have a disability, would be covered. So there was a law that was passed in 2008. It was called the ADA Amendments Act. And its goal was really to restore the intent and the protections of the ADA, because we had lots of Supreme Court decisions and local court decisions that really undermined the goal of the ADA and provide accommodations for people with disabilities. So this went into effect January 1st, 2009, and the regulations came a couple years later. Why is this important? Why am I talking about it? Because it restored the basic definition of the ADA, and it did something that I think it is really important for you all, is it talked about certain things. It removed mitigating measures as a reason for not providing accommodations. So if you're taking medicine, we'll talk more about this, you're still a person with a disability, even with that medication. Episodic conditions. Does that apply to what we're here to today? Right. It may be one day you're great, next day not so great, and the third day you can't function. Are you still a person with a disability? Under the old definition and Supreme Court decisions, we'd have said no. Now we can say, even if you're doing really well, we're going to give you accommodations to keep you that way, to give you accommodations, okay? And we've decided that you don't need extensive analysis. Employers used to say, we're going to get more and more and more documentation. Now the law says, nuh-uh. Get some documentation. If it's enough to say you have a disability, you have a disability. Okay? And we broadened the definition of regarded as. Okay? So that means that it's easier for an individual to meet the definition of disability. And we don't want to do a lot of analysis. Like I said, we don't want lots of doctors' records. So we redefined substantially limited. It's not as a high standard as it used to be. We're now looking at major bodily functions. This really is exciting. You may not be as excited as I am about it. But major bodily function is really important. And we're going to talk about why that is critical. Mitigating measures. Things like medicine, as I mentioned, and then episodic. Okay. Impairments that will substantially always meet the definition of a person with a disability include things like deafness, blindness, intellectual disabilities, partially or completely missing limbs, mobility impairments, including use of a wheelchair or walker or other devices, obsessive compulsive disorder, schizophrenia, multiple sclerosis, muscular dystrophy, major depression, bipolar, post-traumatic stress disorder, autism, cancer, cerebral palsy, diabetes, epilepsy, HIV, AIDS. All of these are really defined in the law. Now, it doesn't mean that this is all, but what happened in the previous iteration of the ADA, it did not include any of those as defined. It said those three broad categories. And so we had lots of judges saying, well, you have cancer, that's not really a disability. And it was like, wow, if you've never had any of the treatments for cancer, they can be incredibly disabling. So now we have much broader definition. And we have more definition of what a major life activity is. as I mentioned before. So caring for oneself, performing manual tasks, seeing, hearing, sleeping, walking, standing, eating, bending, thinking, communicating, breathing, learning, reading, interacting with others, speaking, thinking, reaching, are all major life activities that are now defined in the law. So it makes it easier for folks then to look at how disabling conditions can be. So we talked about major life activities, and then we're going to look at bodily functions. This is really critical to you all. So we're looking at immune systems, normal cell growth, which would be a cancer, right? Digestive issues, bowel, bladder, brain, circulatory, cardiovascular systems, neurological, respiratory, endocrine, lymphatic, musculoskeletal, sense organs, skin organs, genital urinary, and reproductive functions. So you can see now we've really broadened out what a person with a disability is. And it's really helpful for you all to be able to use the ADA amendments definition to say, yes, I have a disability under the ADA, and look, this is where it says, and this is how it plays out. So what does Title I, the employment provisions, cover? It's not just working, but it's the outreach and application process and testing that might need to be accommodated. Interviewing and hiring, the assignments you get, evaluation and discipline, medical examinations, compensation and promotion or on-the-job training are going to be affected by the ADA. Layoff and recalls, termination, the kind of leave you get, and benefits of employment like health insurance and access to other kinds of things that every employee gets. So what does it say? It says qualified individuals with a disability have comparable access to the employment process and are afforded an interactive process excuse me, to determine reasonable accommodation. Interactive is really, really important here. You as an employee or as an applicant needs to be able to engage in that interactive process, and the employer needs to engage as well. This is one law that really requires people to talk to each other. Not many laws do that, do they? And then we're going to look at all aspects of the employment process, which includes if there's gym application and membership. That's included as well. Okay. So who is a qualified individual with a disability? We talked about who a person is with a disability. Now who's a qualified individual? And that's somebody with a disability who has the skills, the experience, the education, any other requirements of the job that can perform the job with or without reasonable accommodations to do the essential functions of the job. So this is really, really important. You must be qualified. Remember, it's not a you have a disability so you get the job. You have to be qualified. But you're entitled to changes in the way the job is done to allow you to do the job. So what does that look like? So what makes a job essential or a task essential? How many people there are to do the job, if the position exists to perform it, and if it's highly specialized. We're here to talk about reasonable accommodation. What does that mean? It's a modification to the job application process. So an example, if somebody is deaf and it's at an oral interview, then having a sign language interpreter there in the application process is critical for the person to get the job, even though they're not hired yet. Modification to the way the job is performed, and then again, those equal benefits and privileges of employment. The accommodations that you can ask for are dependent on the specific requirements of the job, the needs of the employee or applicant. So everyone's may be a little different, and a different day, different time, you may need different accommodations. And the extent they can be done without an undue hardship, which is an incredibly high standard. So what is the accommodation process? The employee must let the employer know that he or she needs an adjustment or a change in their work because of that disability. So this is a point where you are going to need to identify, I cannot do X because of my disability. Doesn't have any magic language. You don't have to say, under the Americans with Disabilities Act, I am a qualified individual with a disability who needs a modification to the way the job is particularly done. You don't have to do those magic words. But you can say, I have whatever. I'm having a difficult time doing whatever, and I need a change. Okay? So no magic words, but you have to initiate that. Or it may be that the employer will say, your performance is not up to par. How can we assist you? And that would open the door. But you have to identify the disability. The employer may need to identify your disability because it may not be very obvious. Now, if I ask for an accessible restroom and I'm sitting in a $30,000 power chair, you probably don't need much documentation, right? But if you're asking for a modified work schedule and specific air-conditioned office and 10 other things, yeah, they're going to want and are entitled to documentation. And then you need to identify what functions of the job you cannot do. The employer consults with the employee about, remember that interactive process? What is it you need? How can I assist you? How can I help you to reduce or remove those barriers? And then the employer's obligation is to take the most appropriate actions to provide those accommodations, taking into account the preference of the individual. But the employer is the bottom line. They make the final decision on what will work. So what are some examples? Using assistive technologies, we've got a ton of accommodations out there now. There are things like for screen readers, something called JAWS, audio to text software. An easy one, and lots of people want this, right? Change in schedule. Maybe changes in break time. Instead of getting longer breaks, taking them in 5-minute segments so that you can stop, go to the bathroom, get water, eat salty snacks, any number of things. Work from home. A change in the work location, change in the work environment, maybe having an office in the corner would be more appropriate. Modify or changing the equipment that's used, the breaks to eat the salty snacks, allowing fluids in workstations, or taking many breaks to get fluids off-site of your workstation. Maybe an area to lay down or to work prone. More bathroom breaks, individualized temperature controls, a quiet space or headsets, using leave as appropriate, and then reassignment. But this is usually the last option. We don't want to go there unless we absolutely have to. As you saw in that quiz, accommodations really aren't necessarily that expensive. About half, a little over half, costs nothing. The average is about $500. And it appears, due to research, that a great resource, the Job Accommodation Network, which you can find at AskJan, J-A-N, jobaccommodation.org, great resource for finding great ways to accommodate people with disabilities. They've been doing research over the last 25 years and have found that accommodations are getting cheaper and easier for folks. It is much cheaper to accommodate an individual with a disability than have them leave and rehire them. Nowhere does it cost less than $500 to bring in a new employee. So accommodations are cheap. So who can get accommodations? Applicants Again, that's unusual. A lot of employers say, but I don't have to accommodate you. You don't work for me yet. Well, if you don't give me an accommodation to get in the door, I won't work for you. And that's discrimination. Full-time, part-time employees, seasonal and temporary employees. And these are folks who are covered by the ADA who can perform the essential functions of the job. How is that process triggered? As I indicated, plain language. The employer can have a formal process. So once you indicate that, they can say, here is our form. We would like you to fill this out. And then that becomes an obligation for you to fill it out. And the employer is required to respond in a timely manner. So you can't put in your request and then 6 months later they say, oh, yeah, we're getting around to that. Okay? Can they be denied? There is a clause, as I mentioned before, about undue hardship, but it's not a set dollar amount. It's relative to the overall funds. It must be significant and substantial, and you have to look at all other resources, including tax incentives or equipment donation, things like that. How is an accommodation decided upon? The interactive process, as I mentioned. Go to the person first. We encourage employers always. And so you, as an individual, need to know what is it you want. When you say you have a problem, are there things you can specifically ask for that you know will make a difference for you? And the most expensive accommodation isn't always the best one. So you need to do it individual. What is it that you need with the job, with your disability, with the environment? Okay? I would like to ask you to do an interactive exercise with me. I would like you to turn to a partner real quickly. Just find somebody, and I want you to be next to each other, okay? And I want one of the persons to have a closed fist, and I want the other person to try and open it, okay? So do that real quickly. Turn to each other. Okay. Did anybody get their hand open? No? Not without a lot of work? You know, I've been talking about the interactive process a lot. What way might have worked? Would you open your hand? Okay. Remember that interactive process. Maybe working smarter, not harder. All right, want you to think about that when you think about the interactive process. Medical documentation, can it be collected? The employer has the right to ask for documentation, as I mentioned, but it must be job-related and consistent with business necessity. So you don't have to turn over all your medical records, only justification for the accommodation you're looking for. Okay, and that's really critical. They don't have access to all of your medical records. You can give it if you'd like, but they don't have the right to ask for all that documentation. And once they get it, that medical documentation must be kept separate, and it's confidential, and it's separate from the work file. And that's really, really important, because no one else has a right to know your medical information. And that's why it's separate. Who else can be told? We said it was confidential. Only coworkers directly impacted on the accommodation can be told that there's a change, but not why there's a change. Just we're doing things differently. And again, that interactive process, that communication. An employer can say it's being done because we're required to by law, and not say what law. Because saying it was the ADA then tips them off that it's a disability-related law, whatever. And that we would do the same for you should you need a change in the way you do your job. But they cannot tell another coworker what your disability is or why they're doing it. Again, that information is confidential. You can choose to disclose should you choose to. But an employer is only going to disclose as much as necessary to keep you safe in the workplace. What are some accommodations that are not reasonable? Putting an applicant with a disability in a job that they did not want, they didn't apply for. Putting them in a position would be a direct threat to themselves or others. And maintaining the salary. Let's say that you're a supervisor 3 position and you can no longer do that job due to your disability. We tried all kinds of accommodations, nothing worked, but you could do the supervisor 1 position and that works, then you're eligible, should there be a supervisory 1 position open, to take that job, but you don't get the supervisor 3 position salary, you get supervisor 1 salary. You have to take the lower salary because it's commensurate with the job you're doing. Okay? Other things that aren't reasonable, eliminating essential functions of the job, lowering production standards. So if you have to do 10 cases a day and you can say, well, you know, I'm a person with a disability, I should be able to only do 8. No, that's not the job. We'll provide you accommodations to do 10, but we need you to do 10. And if you can't do 10, then you're no longer qualified, right? You can't do the job. Providing personal items like a hearing aid or a wheelchair, or creating a job. Well, if you took a little bit from Joe and a little bit from Sam and a little bit from Sue, I could do all those. They're not required to do a brand new job. Now, they may choose to, but they're not required to. And I hear this a lot in our TA line, our information line. Well, I could do Joe's job. If you promote me, then I could do that. Well, I'm not going to necessarily promote you just to provide an accommodation for your disability, right? Or if I get Joe's job, I could do that. But we're not going to fire Joe so that you can take that job, right? Okay. Again, that disclosure issue, which is a really hard decision to make. An employer must provide an accommodation to the known physical or mental limitations of a qualified individual or employee with a disability. So it is your right to disclose your disability and your need for an accommodation, okay? But you need to be able to disclose it to get an accommodation. And you can limit how much you want to disclose. But an employer is not required, nor do we really want them to say, you have a disability and you do. I don't think you do. You look normal. You're fine. Oh, you're very disabled. We don't want them to do that, right? So we want to presume everybody's fully capable. And then when we raise our hand and say, I have a need for an accommodation, then we have to disclose and determine how much we disclose in order to get what we need to allow us to do our job. So, a review. New regulations are especially beneficial for folks with dysautonomia. Bodily functions, big deal, right? Because it really addresses what some of your major concerns might be. We now have a less rigorous definition of disability. Episodic or those in remission are now covered. Huge, 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 huge. And you only need to disclose when asking for a reasonable accommodation. Now, I've got some great resources for you that I think may be helpful. The Equal Employment Opportunity Commission, EEOC, is where you'd go to file a complaint if you feel that all else failed and you need to complain. You would go here. Or your Human Rights Commission, because many of them, almost all of them now, have the same kind of coverage, even maybe better coverage. They may have 10 employees or 1 employee like the District of Columbia. So they may have even better coverage, but you can usually go to your Human Rights Commission. And I often recommend that folks go to their Human Rights Commission because sometimes they're a little bit more nimble and they're a little more aggressive in pursuing cases than EEOC might be. The job accommodation, as I mentioned, askjan.org is a fabulous resource. Lots and lots of great resources online, and you can call them as well. And the ADA National Network. My center is one of 10 centers in the country. As was mentioned, I'm with the Mid-Atlantic ADA Center, and we cover the District of Columbia, Delaware, Maryland, Virginia, West Virginia, and Pennsylvania. But there are 9 other centers around the country. We have a standard 800 number, 1-800-949-4232, and you can call us, anyone can call us, and ask us anything about the ADA or just questions you might have that relate to disability. And we will get you to the next stop. If it's not something that we can answer, we will help you figure out who that entity is so that we can help you. So you can have employers call us if they don't believe that, this is covered. You don't have to be the only source. They can call us. We're real good at helping translate the ADA from a technical law into English, and then how we get to the next steps. So we hope to be able to get you to a place where you understand the law, give you information or resources to be able to use the law as an effective tool to get the accommodations you need to be able to work effectively. At this point, I would like to take any questions.
I'm wondering just about the application process.
Okay.
And what you do before you've been hired and when to disclose any disclosures you might have.
Great question. The question was about disclosure. When and how do you disclose? As I said, you really only need to disclose when you need the accommodation. So my recommendation is, unless you need the accommodation during the application and interview process, don't disclose. Because there is no real value, right? Unless you need that accommodation, there is no. An employer can't say, well, you lied to me, you didn't disclose a disability. The only time that you need to disclose a disability, unless on medical forms and things like that, is when you need that accommodation. So if things change, you may be able to work for a while, things are going great, then all of a sudden they're not. Then you can disclose the accommodation and determine what accommodations you need. But you do not have to disclose at any one particular time.
Can I do a quick follow-up?
Sure.
If you're hoping that you can do some of the hours from home and it seems like that might be possible for the job, but it isn't listed in the job description, then in the application process you would sort of need to disclose that, right?
I would say no. I would still go through the application process.
You would not ask for the time from home.
And then when they offer you the position, then you can negotiate and talk before you start. But, there may be lots of flexibility or not. You may know from just the job description itself what kind of position may or may not. You can absolutely disclose, and if it's really something that's critical for you, you can say in the application, again, you can disclose at any point when you want to disclose that. But if that's, a hard and fast need for you, then you might want to, before you go through the application process, say, I'm very qualified for this job. I'd like to be able to show you my qualifications, but I do need to have this be part-time work at home. Is that even a potential? And you could then, see what they say, and then you may want to throw in, I have a disability that would, require this kind of accommodation. So you can do any number of things, but it's your choice to do so. And it's, there's no one right answer. It is complicated.
Two questions. Number one, are there any employers that are too small, like small businesses, that don't have to comply with this? And the second one was, is there a period of time you have to work for an employer before you are eligible to get accommodations? For instance, my daughter's job, she was told she had to be there for a year.
No, she's not required to be there for a year. So the last one, what kind of what time frame? As I said, you can start that at the application process, and it starts from the moment you start interacting with that company all the way to the point that you leave or are fired. Any point in that time frame. Now, what they may be talking about, maybe the Family Medical Leave Act. So if it's FMLA, Family Medical Leave, there are time standards, but not under the ADA.
So how does that how does that differ? So a lot of big companies have to put in FMLA forms in order to get the, in order to get the accommodation.
Well, if the accommodation that you're asking for is to take FMLA leave, to be able to leave and get the supports from the FMLA, then that's not covered under that's not an ADA. So you need to separate those two. But if it's modification in the way the job is being done, and it's not just leave, because the ADA, and it gets very complicated, I'd be happy to talk with you about it, they can overlap each other. So I'd be happy to talk with you more about that. And then your first question, I'm sorry.
Are there any small employers, like small businesses that are exempt from these types?
Well, any business that's less than 15, unless your state law has less, and always check your state law to make sure, because as I indicated, the District of Columbia has, one or more, so that covers everybody. But small businesses under 15 are not required to comply with the ADA. But honestly, statistics show us that small business very often are more than happy to comply because they, a lot of times, recognize the value of people with disabilities and are looking for good talent and are willing to make the accommodations that maybe larger companies don't. So a lot of times we find that they will use the provisions of the ADA even though they don't have to as a benchmark for doing it. But if they're less than 15, they are not covered under the federal ADA.
How do you recommend you handle it if you're not given a job and they blame it on something else, but you're pretty sure it's because you're asking for accommodations or because you're disabled?
Well, if you're pretty convinced that you were fired or weren't given the accommodations that you request, you can file a complaint with the Human Rights Commission and or the EEOC, and they will investigate, and they may be able to find evidence. Obviously, if you have evidence, and so one of the things that people feel they're discriminated against, I always recommend start a diary, start documenting, do everything you possibly can day to day to be able to document what you feel is discrimination. But then go to these agencies. One of the recommendations would be to ask for mediation, because both entities usually have a EEOC definitely does, and most human rights commissions do as well. And that gets people to the table. And a lot of times it ends up being sometimes a miscommunication. I didn't really understand that that's what you needed, or that you were saying no and you really thought I needed this. And so sometimes it's just something as simple as that, or having that third party that will help facilitate the discussion. And it gets people to work faster. They don't leave the job. Everybody's happier. So it is a real good potential process to use in resolving those issues.
Under the category of non-acceptable accommodations with the personal items for use, would one of those items be like a normal chair or a stool, or what wouldn't normally be?
Absolutely. So any accommodation like that, a special chair, or being able to sit down more often than most people do. All of those things are not personal items. A personal item would be like this power chair that I need essentially 24/7, or eyeglasses that I need 24/7. But in some places, they'll do a power chair or a scooter if it's incredibly long distances, and then you leave that at the workplace. Or you have glasses specifically designed for use in the computer, and you don't use them at home. You leave them at the workplace. So those are workplace accommodations. So a lot of businesses say, you must stand. If you're a checkout clerk, you must stand. Well, I was just at a grocery store recently where all the clerks sat. So really? People have to stand? They looked like they were pretty efficient sitting. So it is just making people think differently. But those kind of accommodations are absolutely part of the accommodation process.
Okay, thank you.
Mm-hmm. Sure.
Service dogs. So I have a service dog. I don't need any further accommodation other than just letting my dog be with me. That's not technically an accommodation, is it? Because they're covered underneath.
Okay? What you have then is not a service dog. Okay? There are specifications for what a service animal is.
Oh, no, I know. He comes from the ADI organization and everything.
Okay, but does he perform a task for you?
Yeah, yeah.
Okay?
So that the accommodation would be just allowing him to be there?
Well, there are two standards that qualify somebody to be a service animal. One is it's needed for, and these are two questions people can ask. One, is it needed because of a disability? And the other one a person can ask is, what task does that animal perform for you? So if that animal is trained to do a specific task, then it qualifies as a service animal. Not that the animal, I just do better because the animal is with me, and that then becomes an emotional support animal, and that is not covered under the ADA, and you're not allowed to take it into public space.
Right. So, I mean, like, he's a legitimate service dog and he does meet that criteria. Do you need to request an accommodation in order to have him with you? No, because he's covered by the ADA.
Well, you need to identify what kind of, so it may be that, so you would say when you came in to get a job, this is my service animal, this is the, I would be proactive and say, this is a service animal, I'm needed because of a disability, this is the task. I would do that just because you're being proactive. It's obvious you have a dog. Dogs, service animals don't have to have special harnesses or labeling, but a lot of people do just because. But then I would say maybe the accommodation I might need is that maybe different change in my brakes so that instead of two, maybe one specifically to be able to take my dog out. And, maybe establishing, if there's no area near there, a grassy area or someplace that the dog can relieve himself. Those kind of things. And it might be that, an accommodation may be that we need to work out there's somebody who's allergic, and then we'll need to modify how people function in that environment. So there are potentially some, but I would be very proactive and say, this is a service animal, this is why I need it. And that,
It's hard to hide, so.
yeah, exactly. But I would just do that just because it gives people then, the understanding, because their first knee jerk may be, oh no, we don't do that here. Uh-huh.
What are they allowed to ask for service dogs? Because I recently moved from Florida to Missouri, and we stayed overnight in Tennessee with my dog. And you need a Tennessee state issued raised seal letter that your dog is registered as a Tennessee service dog.
Okay, this was a question in going state to state. What is a requirement? The ADA trumps any state law because it's a federal law, unless that state law provides better coverage. So like I said, the example of 15 employees, but in DC it's 1. So that DC law would trump the ADA because it provides better coverage and allows more people to be covered under their laws. Service animals, no, they cannot ask you for documentation. Under the ADA, that is illegal. That is illegal. They cannot ask for a letter, a state certification. A service animal is a service animal. They can ask you those 2 questions that I identified. That is all they can ask.
And if they say no, don't let your service animal on the property, who do you go for that?
You can then file a complaint with the State Human Rights Commission and see if it's covered under their regulations. Many times it is. You can also file a complaint with the Department of Justice, and they would then possibly, although they get hundreds of thousands of complaints and may not get to yours, but that is an option. So one of the things you need to do is be very proactive and understand your rights. On the website of the information I have up here that I'm happy to share, there are fact sheets that you can then take. There's one from the Department of Justice with their logo on it that talks about what people can and cannot ask about service animals. I work with the lodging industry. It's still a challenge, but have them go back. If they belong to an association, the American Hotel and Lodging Association, the Asian American Hotel Owners Association, or other entities, will help them clarify that they are wrong in what they are doing. So there's any number of ways. You can go to the State Disability Commission as well and let them know. I mean, they don't have enforcement authority, but they may be able to help in that education process. Not going to help you on the spot there, but if you're well educated about what your rights are and have materials and resources that you can share with someone, you might be able to talk them down. And I always then, usually it's a clerk, I want to talk to the manager, I want to pursue it, I want to go further, especially, if you're traveling and this is a hotel room that you need. Okay? I have got time for one short question if someone has it, and if not, I'll wrap up. And I'm happy to talk about issues afterwards. I've got materials up here on the ADA. We'd be happy. We passed around our sign-up sheet. We've got lots of great resources. Please call your ADA center. I've got brochures that'll show you where your local ADA center is. And that 800 number I gave you was for any center in the country. It'll get you right to your center. So thank you very much for your participation. I hope you enjoy the rest of the conference.